Welcome once again to Lehto's Law. Here's Steve Lehto.
Francis Springer, who is an attorney, sent me a note. Says, Steve, check out the new law in Mississippi and how it affects your ability to, demonstrate in front of the Capitol building in Mississippi. See, Mississippi's new state law restricts citizens' rights to protest. Well, the question is, does it? I think it does. Mina Corpus wrote this from MississippiToday.org. Whether Mississippi can limit impromptu citizen protests around state-owned buildings rests now with a federal judge overseeing a lawsuit challenging how a state-run police and court in Jackson operates. It was called Senate Bill 2343, passed in the last legislative session, became law in July. The law requires prior written approval for public demonstrations on a street or sidewalk at the Capitol or state-owned buildings or one where a state agency operates by the Public Safety Commissioner or the Chief of the Capitol Police, which falls under this agency. So it's a little confusing here, but I went and read the statute so you don't have to. And the statute's even more confusing the more you read it. But basically, the law says that if you want to have an event, that's the word it uses, an event, in front of one of these places or at one of these places, you've got to submit a request for a permit 30 days before you have your event. 30 days. So if something's in the news right now that really ticks you off, quick, go apply for a permit so you can protest a month from now. So at an August 8th meeting, Public Safety Commissioner Sean Tyndall said the agency is considering the First Amendment as it drafts regulations, and it wants to balance a right to speech with public safety. The agency spokesperson did not respond to a request for comment. So the law was written and said that these commissioners get to draft the legislation to implement it, but we'll get there in a second. Critics of the bill say the law would limit the right to protest that is founded, in the First Amendment, and it could have a chilling effect on speech because of potential consequences, such as arrest, conviction in the soon-to-be operating Capitol Complex Improvement District, and possible time served for a misdemeanor at the Central Mississippi Correctional Facility rather than a county jail. It's the law itself where the problem lies, says Frank Rosenblatt, a Mississippi College School of Law associate professor who teaches classes about constitutional law and the First Amendment. In First Amendment law, speech regulations in a traditional public forum, such as sidewalks and public streets outside state-owned buildings, typically need to meet several requirements. They must be content neutral, narrowly tailored to serve a significant government interest, and leave open alternatives for speech. The professor does not believe the court will be satisfied with the department's blanket explanation of public safety as a reason to restrict speech. U.S. District Court Judge Henry Wingate granted a preliminary injunction of the bill last year in an ongoing lawsuit that consolidated a challenge of the law with a suit challenging House Bill 1020, which established the district we're talking about in its court, and that directed state officials to make judicial and prosecutor appointments to the court. Because a preliminary injunction is still in effect, DPS currently cannot enforce any regulations it adopts stemming from the law. Under the Mississippi Administrative Procedures Act, a public meeting about any state agency's proposed regulations can be held if at least 10 members of the public request such a meeting in writing. The threshold was met for the regulations, so there was a meeting in August early about this. Rosenblatt, one of his law students, spoke during the public comment section and said they were seeking clarity about how the agency is writing the regulations, including how it would consider the First Amendment, how it defines public safety, and well-being. So draft regulations posted in the state's administrative bulletin refer to a number of types of demonstrations, including parades, athletics, block parties, festivals, and other special events where they expect to be 25 or more people who could be reasonably expected to block entrance and exits from any state building. Requests for approval need to be submitted at least 30 days before the event date, and then approval or denial would take place no longer than 10 days after receipt of the event's pre-established route. Action on special events will be taken no longer than 4 days after request for approval. Written notification will be provided of the request's outcome, including reasons for conditional approval or denial, according to draft regulations. In recent years, there have been a number of protests, as you might imagine, at the Capitol and other state buildings. including some about things such as Jackson's water system. So a proposed 30-day minimum notice can limit people's ability to protest about current events, says Rosenblatt. All of those things be off limits for people to speak about. Now, some people like to play the devil's advocate and say, Steve, all it sounds like is they're saying if you want to have a parade, you got to get a permit. Oh, I have no problem with them saying you need to get a permit to do certain things. So let's suppose you're going to have a rally on the front lawn of the Capitol building. You're going to build a stage, put up a sound system, have bleachers. Obviously, you got to get a permit for that. Otherwise, 3 groups might show up on the same day trying to put up stages and sound systems. There's some things you have to organize. But what about the spontaneous demonstrations that people have where they watch the news and they see something that makes them so angry that they're fed up and they're not going to put up with it anymore? They go outside, next thing you know is a group of people who are upset and angry. It happens, right? Oh, I'm sorry. Submit a permit application, and 30 days from now, we'll let you protest. We'll let you demonstrate. But I went and read the statute because I was fascinated by this. And the statute is lengthy and convoluted, but it does say at one point, written approval from the chief of the Capitol Police or the commissioner or the Department of Public Safety shall be required before any event occurs, which will take place on any street or sidewalk immediately adjacent to any building or property owned or occupied by any official, agency, board, commission, office, or other entity of the state of Mississippi, or which can be reasonably expected to block, impede, or otherwise hinder ingress thereto and or egress therefrom. The Department of Public Safety shall promulgate rules and regulations to effectuate the provisions of this paragraph. 2 things of note. One is it speaks about an event. Second of all, it talks about ingress or egress, getting into or out of a building. I assume there are already laws on the books that say you cannot block the entrances to the building and keep people from going in or coming out. So you don't need another law that says that. And certainly I assume that you're not going to get a permit and say, I want to block that door 30 days from now. They're not going to give you a permit for that. So it's already illegal. So all you got to do is say, okay, skip that. Because why put it in there? Because the reason you put that in there is you want it to look like, oh, that's what we're doing here, is public safety. No, that's not what they're doing here. Because there's already laws against blocking those doors. Now, the bigger problem I have is says, shall be required before any event occurs. Any event. What's an event? Seriously. So if you look up an event in the dictionary, because I didn't see a definition of it in the statute, a thing that happens, especially one of importance. The example they give is one of the main political events of the late 20th century. It does also say a planned public or social occasion, such as an event to raise money for charity. But it's a thing that happens. And so it says public safety shall be required before any event occurs. Does an event require more than one person? Not necessarily. But I know what you're going to say. You're going to say, Steve, they can't claim that you are an event if just one person shows up and they're standing on the front line of the Capitol going, I'm mad as heck and I'm not going to take it anymore. Okay? They're not going to claim that that's an event for which you should have gotten a permit. 2 people? What about 2 people who are chanting and timing how they move their hands together? Coordinated efforts. How about that? Is that an event? 3 people. What about 4 people who are not standing near each other and don't know each other? 1 person over here, 1 person over here, 1 person over here, 1 person over here. Is that an event? And so whenever you see vagueness in a statute or an ordinance, it causes problems because how it's going to get interpreted. And so we know what this is actually about. This is about them wanting to control what happens outside these buildings with respect to people who are unhappy. Because I suspect if a bunch of people showed up one day spontaneously to celebrate how much they love the governor and how much they love the legislature and how they want to praise them for doing such a wonderful job that we're certainly going to just put you guys all back and gals back in office at the next election to continue doing your great work. We are just here to applaud you. Are they going to send out the Capitol Police and have you arrested for not having a permit? I bet they wouldn't. I bet they wouldn't. However, if you show up wherever the people are who run the water district or whatever it is, and they're there to complain about the water system, and they're out there making some noise because they're upset about the water, guess what? The cops are going to show up and goes, where's your permit? Don't have one. How do we get one? Apply for it, and we'll let you know in 10 days if you can march in 30 days. Really? Really? And by the way, there's a problem there too. Let's assume, arguendo, let's assume for the sake of argument that there is a legitimate government concern about regulating, controlling demonstrations, whether for, against, or neutral with respect to government. 30 days. There are some things that happen on shorter notice than that. It very well could be that something happens right now that gets people so riled up that they have a legitimate gripe to go protest, but 30 days from now, it might be too late. And as we all know, other things are going to happen in the next 30 days, and that moment might pass. So here's a problem. And this new state law does restrict citizens' right to protest. Apparently, the way this worked, though, is the legislature in the state kind of passed the ball off and said, okay, somebody else is going to draft the rules and implement the rules. But it does say specifically that written approval from these various authorities shall be required before any event occurs which will take place on any street or sidewalk immediately adjacent to any building or property, owned or occupied, and it becomes very, very expansive, okay? And so the question then becomes, is this rulemaking entity going to define what an event is? And how are they going to do that? And so as of right now, number one, a federal judge has blocked the implementation of this law. Number two, there's this organization that's going to draft the rules to implement this law. We'll see what that does. But as it is right now, it's an interesting concept, and I mean that facetiously, because it's a scary concept. Because for them to say that if anybody wants to do anything out here that looks like an event, they have to get a permit, and they have to get it 30 days before they want to hold their little event. And so I suspect that will not withstand judicial scrutiny unless they find some way to write the rules around that. Because what do you do if something happens today and people spontaneously want to go out there and protest? And that's happened, by the way. There have been many occasions where people have seen something and they've spilled out into the streets to react to it. And if you're saying it's public safety, keep in mind that all of the things that you are going to list that could happen are probably already illegal. So you don't need new rules to say you can't block the fire escapes of the Capitol building. Obviously you can't. So don't say that's why you need this. It's not why you need this. So Francis Springer, thank you for sending that to me, my friend. Francis is a lawyer. Mina Corpus wrote that from MississippiToday.org. Does Mississippi's new state law restrict citizens' right to protest? Yes, it does. But we'll see what happens with the court. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The best luck of all is the luck you make for yourself.